In a close call judgment, the Constitutional Court decided against awarding damages to residents of the Winnie Mandela Informal settlement in Ekurhuleni. So they were asking for 15 million rand in damages from the municipality for failing to provide them with RDP homes. In handing down the judgment, Justice Chris Jafta said constitutional damages could not be awarded to enforce socio-economic rights. Now, the Socio-Economic Rights Institute represented those residents, and Executive Director Nomzamo Zondo joins us now for more on the story. Nomzamo, you were telling me off air that yesterday you were mourning the judgment. Today you're ready to move forward. But, you know, take us back to yesterday and just the feelings you had having been with the case for this length of time, that decision coming out of the Apex Court.
Thank you so much, Michelle. So I think firstly, we were in open court with some of the clients listening to the judgment. And the judgment that was handed down by and written by Judge Majid, firstly, I think for our clients, they felt seen, they felt valued. In fact, the fact that their lives have been valued by that judgment, and they could hear, in fact, if you read that judgment, you get to understand their full journey from 1998 up to today. Unfortunately, that was penned by 4 judges against 5, 3 of whom find that you can't award constitutional damages for socio-economic rights cases. Interestingly, the other 2 judges were uncomfortable with that conclusion. So we sit with the possibility actually now that the court is saying that you can expect constitutional damages for socio-economic rights cases, but it will have to be in peculiar and particular circumstances. If you look at this group of clients specifically, they applied in 1996 to 1998. They are approved by 98, and subsidies are paid out in their name, and houses are built in their name, but they never get those houses. They spend about 10 years engaging the state, the presidency, the provincial government, the municipality itself, to get those houses, and they are always turned away. They approach SERI, and when they approach SERI again, we continue with that engagement, including going through Chapter 9 institutions. And in 2015, they launched this litigation. And by 2017, they have a judgment in their favor that says, give these people houses to replace the houses that have been stolen from them. And a deadline is set of June 2019 eventually. And that deadline has now passed. We are 2.5 years away from that deadline. And we are not anywhere closer to them receiving houses. And that's the reason why this community asked for constitutional damages, because they said, if that court order means anything, something must sit in our hands until we finally get to live in our houses. I think when I spoke to you last week, I explained that for us it's been very, very hard, because in 2020, some of our clients passed away. 5 of them passed away in 2020. And one of them was one of the oldest applicants in the case. So it would also been very active, Mr. Mayepa. And he passed away having received nothing, despite at that time already being 1.5 years away from the deadline.
I mean, it's a bitter pill to swallow just because it was such a close call judgment, 5-4.
Look, that is true, right? And in fact, Justice Majid kept repeating that if he'd been able to convince other judges to join him, he would have, for instance, given relief of an amount of 10,000 rand as damages to the community, of a supervisory order where the municipality would be forced to come and report to the court on what they are doing to comply with the order of justice, therefore. And then he also said he would have even given the residents an opportunity to come back to the court 1 year later if they still don't have their houses. And for us, it's not the issue of constitutional damages is not that difficult to swallow. But it's the fact the court gave us no relief. At this point, we've been sent away from the Constitutional Court without any relief, and we must start afresh to bring a contempt application against Ekurhuleni for having failed to meet the order that was handed down in 2018.
Sure. I can just only imagine how devastating that must be for you and for the people that you represent, Nomzamo. Just reading through the summary that is on ground up insofar as this Constitutional Court decision is concerned, one of the issues that I find quite difficult to understand is what Justice Chris Jafta said about the right to housing. He says the failure to provide a house cannot cause an injury or damage to the individual in need of a house. Without injury, there can be no claim for constitutional damages. I mean, how do you, you can explain it to us, this issue around a right to access to housing, but that the state doesn't have to answer that right with giving you a house. Just explain that to us.
Sure. So what the Constitution provides for, right, Section 26.1 says you have a right to access to adequate housing. But Section 26.2 places an obligation on the state to meet that right by putting in place reasonable measures that are within their available resources, and of course that are also ensuring there's progressive realization of the right. Now, what Justice Jafta says that is an obligation on the state to put in place policy, right, which they have done. So we have the policy and legislation. So we have the Housing Act, we have the National Housing Code, which is what our clients had applied through in order to be awarded the RDP houses. And it's a failure in the implementation of the National Housing Code that has brought us here. We don't, of course, as an organization and as the legal representatives of the occupiers, we don't agree that the residents, they don't have a right to come and complain if the measures put in place by the state fail to ensure delivery of houses to them. And I'd like to maybe make it more practical. So one, you have people who have applied for housing, and there are millions, right, who have not yet received housing. That's one group. And it makes sense to say that group can't come to the court and say we seek damages, because they've simply applied and are waiting to go through the process in the National Housing Code. Then you have the second group who has applied and been approved, like our clients, but haven't received their houses. Again, in our case, we're not arguing for that group, because we're arguing for a different group, people who've gone even beyond saying we're approved. They've engaged the state, and they've even gone to court to enforce their rights. And their enforcement has been rendered empty and hollow by the state's refusal to deliver those houses. Yeah. So it makes sense, just that it says the millions of South Africans are still waiting on the housing queue, on the housing list, can't come and sue. But people like Ndeletu Bakale, who've gone beyond, who've even come to the court and said, I have now gone through what the state has told me I must. I've spent my time on the queue. I've come to the end of the queue, and instead of being given a house, my house has been given to somebody else. And then again, his request at that time is, give me a house. And then that request, after a court confirms it, is ignored by the state. That's why we're here.
So Justice Chris Jafta also saying in his decision, I think part of what he's saying is that the residents jumped the gun in approaching the Constitutional Court, because he says they had various remedies at their disposal. They should have applied for a contempt of court order when the municipality didn't comply with the order of the lower court, or they should have sought eviction proceedings against the legal occupants of the houses that you've just described to us. And then again, Judge Majid on this point, differing with the majority judgment, saying that eviction notices would likely not have succeeded anyway.
Definitely. So there's already a judgment of the Constitutional Court in Matale versus Linda of a person who is in this community who sought an eviction order. And the court refused that eviction order. The Constitutional Court refused that eviction order. And the standard in terms of getting an eviction order, it would be whether it would be just and equitable for the person to be evicted. And that standard would have to be met in each and every individual case. So first of all, the people that are living in Winnie Mandela themselves are people who are likely not to have economic power and are likely not be able to house themselves. So when an applicant goes to court and says, I want this person evicted, you sit with a problem where you can end up with a result that says you can't get an eviction, and they still back where they started. And that's why Justice Majid said that's just simply not a solution. In any event, the obligation is then being placed on the 133 people who did not cause this problem. It would even be better if Justice Jafta had said the municipality must ensure that there's evictions. And then there's a further legal complication. When you bring an eviction application, what you need to claim is that the person does not have the consent of the owner or the consent of the person in charge. Now, the people that are living in the house that we built for our clients have had some engagement with the municipality. We know that at times the municipality even colluded to make sure that they provide them with services and changed our clients' names in the utilities bills and information in the municipality. So those people would like to have an argument that they have the consent of the municipality, who in most of the cases remains the owner of the land and the house that the client those people are on, the clients are still waiting for. So that would not be addressed. So when we brought this case, the issue of eviction was something that we discussed at length with the clients and the complications that would come with that. And our clients wanted one, of course, the quickest resolution, but one that would, in the end, would ensure that all of them end up with houses. And that's on the path that we still remain on now.
Yeah. So effectively, the municipality, Ekurhuleni, gets away with the kind of collusion and corruption that you've described to us.
That is the unfortunate part, right? I think yesterday, the people who attended court on behalf of the municipality were, of course, relieved, and I'm sure didn't believe their luck. But their luck because the judgment really just said the residents must go away. But at the same time, the one thing that I started with earlier is that now the experience of the 133 households is fully set out in the judgment of Justice Majid. The mistreatment that they've suffered in the hands of Ekurhuleni appears in the most glaring terms in that judgment. Even in the judgment of Justice Jafta, you do not see him justifying the actions of the municipality. And at this point, really, we are sitting under a month after a new administration has taken over from Ekurhuleni. And we really hope that that new administration would want to change the narrative of these and the experience of these residents of how they can be treated by Ekurhuleni. Yeah. We hope that the new administration would then come back and say, actually, what can we do to make sure these 133 households are housed as quickly as possible?
Yeah. Next steps, very quickly, Nomzamo. Next legal steps.
So we are, at this point, the court has said to us, we must consider a contempt application. It's clear to us that the municipality would have a hard time opposing a contempt application. But unfortunately, here we're talking about houses, so we can bring a contempt application. But how does that contempt application make sure that houses are eventually delivered for our clients? So we are now at this point engaging on bringing that contempt application. We are also going to go back to the municipality to say, we don't have constitutional damages, but we are 2.5 years away from the deadline that was set for you. What are your plans?
Nomzamo, and we wish you and those residents all the very best. Nomzamo Zondo is the SERI Executive Director. Devastating decision in the Constitutional Court just yesterday about the awarding of damages to those 130 residents of the Winnie Mandela Informal Settlement in Ekurhuleni. Nomzamo, thanks for your time this morning.